Section 3. Bilateral, unilateral, valid, void, voidable, and unenforceable contracts. Can I just cancel the contract? Monday morning arrives, and Ashley's phone rings before she has even finished her first cup of coffee. It's David. After telling Ashley on Friday that he missed a mortgage payment, David spent the weekend worrying. He reviewed his bank account, his business expenses, and the amount he still owes on the property. Now he's nervous about selling. Ashley, I've been thinking about everything, he says. With all this financial stuff going on, maybe I shouldn't sell right now. Can we just void the contract? Ashley hears a word that real estate agents hear constantly: void. Clients use it casually. Agents sometimes do too. The contract is void. I want to void the deal. They missed a deadline, so the contract is automatically void. But in contract law, words matter. Before Ashley answers David, she needs to understand what those words actually mean. Start with the type of promise. Let's first look at a simpler distinction: bilateral versus unilateral contracts. A bilateral contract generally involves an exchange of promises. One party promises to do something in exchange for the other party's promise to do something. David's transaction with Marcus and Elena is a good example. Marcus and Elena have agreed to perform their contractual obligations as buyers, including paying the purchase price according to the agreement. David has agreed to perform his obligations as seller and convey the property according to the contract. There are promises on both sides. That is the basic idea behind a bilateral contract. A unilateral contract, by contrast, generally involves a promise made in exchange for performance. Instead of exchanging promises, one party promises something if another person performs the requested act. For an Arizona licensee, you don't need to turn every transaction into a law school examination. What matters is understanding that contracts can be formed through different structures and that the parties' obligations depend on the agreement involved. Valid does not mean nobody can ever cancel. Now let's return to David. The purchase contract was properly formed. The parties reached agreement, signed the necessary documents, and created contractual obligations. We would generally describe a legally effective agreement that satisfies the necessary requirements as a valid contract. David's financial problems do not automatically make that contract invalid. This is an important point. A seller cannot ordinarily erase a valid contract simply by saying, "I've changed my mind." Likewise, a buyer cannot automatically declare a contract invalid because the transaction has become inconvenient. The parties' rights depend on the contract and applicable law. A void agreement is fundamentally different. If an agreement is legally void, it has no legal effect. Imagine an agreement whose very purpose is unlawful. Calling it a contract on a piece of paper does not magically make an unlawful agreement legally effective. That is very different from David saying, "I don't want to sell anymore." Here's where agents get into trouble. They use void as another word for cancel. Those concepts should not be casually treated as identical. Voidable is different again. A voidable contract is not necessarily void from the beginning. Instead, circumstances may give a party the legal ability to avoid the agreement. Examples can involve issues such as certain forms of fraud, duress, incapacity, or other circumstances recognized by law. Imagine David tells Ashley, "I only signed because the buyer threatened me, so this contract is voidable." Should Ashley respond, "You're right, I'll cancel it immediately"? No. Ashley has now been presented with a legal claim that could affect contractual rights. Her job is not to conduct a legal trial at the kitchen table. She should immediately involve her designated broker and recommend that David obtain qualified legal advice. Then what is unenforceable? An unenforceable contract or agreement creates yet another issue. An agreement may appear to contain the components of a contract, but be subject to a legal rule preventing judicial enforcement. Remember our discussion of the statute of frauds in Section 2. If an agreement falls within ARS Section 4400-100, but fails to satisfy applicable writing and signature requirements, enforceability can become a major issue. Notice how different that is from saying there was never an agreement at all. These distinctions matter because agents should not casually diagnose the legal status of disputed contracts. The most dangerous sentence in the transaction. Now David asks Ashley again, "So can I just void this?" Ashley could create a serious problem by saying, "Sure, you're the seller, just cancel." Instead, she explains that his financial situation does not by itself mean his existing purchase contract has disappeared. She tells David she needs to speak with her designated broker about his concerns, and that if he wants advice concerning his legal ability to terminate the agreement, he should speak with an attorney. That is good brokerage practice. AAC R428-1101 establishes important duties concerning a licensee's dealings with clients and protection of the public, while ARS Section 32-2153 provides numerous grounds upon which ADRE may discipline a licensee. An agent who begins making unsupported legal determinations about disputed contractual rights can create problems for the client, the transaction, and the brokerage. Experienced brokers teach agents to recognize the difference between understanding a contract and practicing law. You need enough contract knowledge to identify the problem. You don't need to become the judge who decides it. David's problem is getting bigger. Ashley calls her designated broker Michael and explains what is happening. Michael asks the question that will change the direction of the transaction. Do we know exactly how much David owes against the property? Ashley realizes they don't. David originally believed he had plenty of equity, but now there is a missed payment, a possible second lien, selling expenses, and uncertainty about the actual payoff. Michael tells Ashley, before anyone starts talking about canceling anything, let's understand what we're dealing with. That conversation will eventually lead us toward the short sale portion of this course. But first, Marcus and Elena's purchase contract contains another important lesson. What happens when the parties later argue that something was promised during negotiations but never made it into the final written agreement? That's where the parole evidence rule enters our story. Online discussion. 1. David tells Ashley that because he missed a mortgage payment, he wants to void the purchase contract. What should Ashley explain? Answer. Ashley should avoid telling David that his financial circumstances automatically make the contract void. A missed mortgage payment does not by itself eliminate contractual obligations between the buyer and seller. Ashley should review the situation with her designated broker, and as David is asking whether he has a legal right to terminate or avoid the contract, recommend that he obtain qualified legal advice. 2. What is the basic difference between a void contract and a voidable contract? Answer. A void agreement has no legal effect, while a voidable contract may be legally effective unless and until a party who has the legal right to avoid it does so. Because determining whether a particular contract is void or voidable can involve complex legal issues, a real estate licensee should recognize the distinction without attempting to make a legal determination for the client. 3. Why is it dangerous for an agent to tell a client, don't worry, the contract is unenforceable? Answer. Whether a disputed agreement is legally enforceable can depend on statutes, contract language, facts, defenses, and case law. An agent who makes that determination may give incorrect legal advice and expose the client and brokerage to unnecessary risk. The agent should identify the issue, involve the designated broker, and recommend appropriate legal counsel when necessary.